I'm delighted to welcome you today for this panel on facilitating and measuring better privacy practices for mobile apps. So this panel today is one of many activities organized as part of a research project on legal apps and privacy, supported by a grant of the Office of the Privacy Commissioner contribution program, notably led by Amy Salyzyn, Teresa Scassa, Jenna McGill, and Suzanne Bouclin at the Center for Law, Technology, and Society. Before giving the floor to our speakers today, I will briefly introduce them. So first, you will hear Lisa Austin. She's a professor and the chair in law and technology at the University of Toronto Faculty of Law. She's also cross-appointed to the Department of Electrical and Computer Engineering. Dr. Austin's research focuses on privacy, property, and legal theory, and she's currently interested in exploring issues at the intersection of law and computer sciences and engineering. Then Amy Salyzyn will talk. She's an associate professor at the University of Ottawa Faculty of Law Common Law section and a member of the uOttawa Center for Law, Technology, and Society. A renowned expert on legal ethics, she is currently working on issues related to access to justice, technology, and privacy. She's leading the OPC grant. She has an early researcher award from the Ontario government to work on technology, on how technology can be used to facilitate a more effective access to justice for Ontarians. She's also a co-investigator on the 2.5 million grant with Université de Montréal on the ethical use of technology of AI in our justice system. Then you will hear from Teresa Scassa. She's a full professor here at the Common Law section and the Canada Research Chair in Information Law and Policy at the University of Ottawa, and as well as a member of the uOttawa Center for Law, Technology, and Society. Dr. Scassa's work is focused on IP, privacy, law, and technology. She has ongoing research on trademarks and freedom of expression, on IP issues in citizen science, on legal issues regarding digital cartography, and various issues related to open governance and open data. Those three speakers will be presenting on their work as part of their respective projects supported by the OPC contribution program. And they joined today by four speakers, Sam Witherspoon, who will be talking about his own perspective as a developer and a lawyer. So Samuel Witherspoon is an engineer and a lawyer. He clerked at the Federal Court of Canada and had a brief experience in private practice. Upon leaving private practice, he built a machine learning-focused business targeting the family law market. And today he's the co-founder of Immersive Data Labs, born as a company focused on natural language processing and classification technology. Immersive is a startup focused on transforming how we manage and interact with written information. And so without further ado, I will hand it over to Professor Austin. Thank you very much.
Thank you. Thank you for that introduction. Thank you for inviting me here today to talk about a project that I worked on last year. So I, along with David Lee, a professor at University of Toronto in electrical and computer engineering, he and I have co-founded an interdisciplinary lab where we try to do projects that are sort of well-served, we think, by bringing law, computer engineering, computer science perspectives together. It's called the IT3 Lab. You're welcome to look us up. And we did a project last year called the AppTrans Project, which we wrote a report for the Office of the Privacy Commissioner of Canada, and we have some follow-up work that we're doing on it. So I'm going to here just today tell you sort of what we did, what we learned, and briefly sort of what some of the broader questions and issues are that came out of that. And I should just say, by way of introduction, I'm the non-technical person on the team on this project. So the technical part of this tool that I'll describe to you, it was built by David and his graduate students, particularly Peter Soon. I'm a philosopher by training, so I'm interested in the issues that are raised by this and in engaging in the policy discussions around some of these issues. Okay, so what is the App Trans project? Well, basically what, I'll say we because it's easy, but with the caveat that I didn't do the technical side of this. But what we were interested in is, could you build a tool that would help not just consumers, because there's a lot of people in the kind of consumer-facing sort of a marketplace, but help developers and help regulators understand what the actual data practices of apps are and whether they're actually complying with the privacy policies that they use. And so what we did is we built a prototype. So it was just really a proof of concept kind of idea. Could you get this to work with what kind of accuracy? And what we wanted to look at in this prototype was, could you take an app and could you take a look at, we were using Android apps, this is an iPhone, so, but could you take a look at this app and understand what it was doing in terms of collecting three kinds of data that we looked at, and that was contacts, location data, and device ID. Was it collecting that data? Was it sending it off the phone? And was it declaring it in the privacy policies? So how did this work? Technically, here's the very short answer to it. It's more detailed in the report, and then we also have more documentation if you're actually interested in getting into the weeds. So what it does is it uses sort of standard tools for static code analysis to take a look at the app, and it can tell whether the app wants to get access to the permissions involved in getting access to the information about your contacts, your device ID, and your location, and whether it wants to send that data off the phone. Then what we did is we have a huge library of privacy policies, and David and Peter trained that. We labeled some of those policies. We used machine learning techniques in order to automate the classification of these policies so that you could take an app, you could scan it, you could figure out whether it was collecting information of these three categories, whether it was sending it off the app, and then you could map it onto a privacy policy automatically and say, is it declaring these collections? Okay, so it was a very simple idea. It was just based on three categories of information, and is it declaring these as collections or is it not? And there's a lot of complications you could add on this, but we were just trying to see, could you get it to work? And the answer was yes. Actually, we got it to work with a fairly high degree of accuracy. And what we did is then we ran it against hundreds of apps that we also had the privacy policies for, and tried to figure out, could we detect which of these apps have non-compliant privacy policies? Now, the results of that were really interesting. The results of that were we found 60% non-compliance on those particular measures. That's a very high number. Now, this is a prototype, and there's all sorts of questions about, whether you could actually use it in the field. We document a lot of that in our report, but 60% of the apps were collecting either location information, device ID, or getting access to your contacts and not declaring this in the privacy policy. So they dug a little deeper and said, well, what's the reason for this? And 80% of the problems were based on third parties. So it was based on the apps using third-party software for doing basically ad libraries, analytic libraries. So when an app developer wants to, say, monetize the app, you want to deliver ads, you put in a piece of third-party software from the ad and company. You stick it in your app. So this is my very technical explanation. and then that's how the third party is going to collect that information. So it was the use of third-party software that was responsible for 80% of the problems of non-compliance in our study. So we thought that was really interesting. What they also did then is there are existing ways in which you can parse the reading level of different kinds of documents. And since we had this immense library of privacy policies, they also analyzed privacy policies against these different grade level assessment tools that were available. those results are also really interesting. Over 75% of the mobile apps policies that we looked at for that part of the study required at least some college level education in order to understand. So if you're thinking, are these policies understandable to most people? The answer is no. Okay, so those were the basic findings when we actually ran that app, the test, and the other finding was just that, this works, and we're exploring kind of two different options. One is to further build in functionality and accuracy and all those sorts of things into this tool in different ways. And the other is to just explore more on the policy side, various more kind of in-depth recommendations for how app transparency can be enhanced on the policy side. So I just wanted to flag a few kind of issues on the kind of broader scheme of things, because we wanted to keep our comments short here and have more of a discussion. One is that I wanted to flag the importance of transparency generally. So too often we're talking about transparency only in the context of informed consent. Transparency is important in the context of informed consent, and I think the finding that the readability of privacy policies is just, strikingly problematic is an issue. But I think that transparency is important if you want to say that apps or anything in our technological world is to be subject to regulation at all. If we can't ascertain the data practices of apps, then they're going to be practically immune from legal regulation. So if we're relying on a process where they self-declare through the privacy policies, and we need to understand, are they actually, those privacy policies complete, or are they inadequate in some way? If we can't do that, if we can't also get under the hood at these technologies, then in what sense are they subject to any kind of legal oversight, or what sense are they in this kind of law-free zone for all intents and purposes? So I think that we need ways of checking this. And so our focus on this project, and our focus kind of continues to be, how do you help developers comply with the law, and how do you help regulators understand whether they've complied with the law, and to shift the focus off of it being the consumers who have to figure this out and make complaints. And there's lots of ways in which I think we need to embrace technology to help do this. Not just, technology isn't just what we need to be regulating, we need to be using technological tools in how we regulate as well, and do it thoughtfully. If any of you are from the regulatory community, there are lots of us in the university who would love to work with you and keep doing this. The second thing that I wanted to flag is there's a set of questions I think that for me very much came out of this, and is something that we're going to be exploring in the sort of policy follow-on to this project, which is questions about whose responsibility is it to comply with the law, for example. And so one of those aspects to that is who holds the apps, since we're talking about apps, accountable for transparency. I think generally we've said it's the consumer's responsibility. And I think that has to change. The consumers can't do this. We know people don't read the privacy policies. The privacy policies are written at a level that people can't understand. We know there are so many problems with this already. But even in this project, the consumers can't understand that there's a problem in that there are information and practices that aren't being declared here. This is not information that's being collected through the user interface. We were looking at information that was being collected through access to these permissions. So there's ways in which people have to get under the hood of the technology to figure out what's going on. So the ability of consumers to even detect problems, let alone then complain about them, is super problematic. So I think there's a failure if we're going to rely too much on consumers. So should be regulators, yes, but how can regulators do this when there are thousands of apps that go onto the market every single day? There's a scale problem here that's enormous. And they have the same problem of how do you get under the hood at how the technology is actually working. So we need to build tools that allow for transparency at scales that humans can't get to, or we're not going to be able to effectively regulate in this area. And so I think that we need to think a little bit more about that, shift the onus to the regulators, but help regulators by allowing them to see what's going on in different sectors, not to replace but just to say, where am I going to focus my attention? Where is it reasonable to proactively investigate? And where do we sort of set those flags for then the regular kind of investigatory process to happen? Okay. The second thing about, who's responsible here is that the basic responsibility tends to get put on the app developer's shoulders. That's the guidance from the Federal Privacy Commissioner. That's when, if you sign up, you go through some of the documentation, you want to say, okay, maybe I'll use the Google Ads or Google Analytics. So all of these third parties say it's up to the app developer to be putting and informing the consumer about how this works and what kind of information we're collecting. And when these articles come out in the newspaper about, like the one recently about Facebook, that says, oh, look, Facebook's collecting all this information from your apps. Did you know that? The response of the Facebooks and the Googles of the world is, in our terms of services, right, it's very clear the app developer has to inform the user of this. So it goes back to, it's the consumer's job to read these privacy policies and figure it out. Don't complain to us if you don't like it. And it's the app developer's job to incorporate this into the privacy policy. And I think that just like we shouldn't be offloading responsibility onto consumers, to the extent we do, we shouldn't be offloading all this responsibility onto the app developers. These third parties are collecting information. They have responsibilities, and they shouldn't be able to just say, it's up to you to figure out what we're doing, stick it in your privacy policy, and as soon as you incorporate our code, we don't have a responsibility here anymore. I think that's ridiculous. And it's not just the third-party code and how it works, but it's also the entire kind of set of tools that developers can use to try to figure out how to comply or not. So there's a well-known problem with the Android, problem from a privacy perspective, with the Android operating system, in that if you put third-party code into your app, that third party gets access to every permission your app has access to. You can't separate them. There's no way of, what they say, sandboxing those two. So if your app gets permission to your context, the third-party code can get access to the context. There's no way of shutting that down technically. So Google built that. Why did they build it that way? They must have an engineering reason to build it that way, but they could build it differently. So they could enable better privacy practices. They currently don't. So there are different places where people have responsibility in this data ecosystem. And what I think we've been too focused on is a framework for privacy law that says, oh, you have an app on your phone. You're the individual. The app is the one collecting your information. So you as the individual are responsible for reading those privacy policies and figuring out what you think is appropriate. And the app developer is responsible for making sure that they're, they declare those practices. But there is this complicated data ecosystem and digital ecosystem that all of this is situated within. There are all these third parties, and there are the people who build the infrastructure about this. All of that plays an important role in whether you actually get privacy. And the responsibilities of those players needs to come to the fore, and the stronger responsibility of the regulators to get off the backs of the consumers and proactively investigate, I think also has to come to the fore. That focusing so much on the app developer and the consumer is not doing anyone a service in terms of privacy protection. So I'll leave it at that, and we can discuss more later.
Great. So I'll talk about our project that was also done through the Office of Privacy Commissioner's contribution program. And looking at the same issue, but from a bit of a different perspective, I think complementary. How do you facilitate better practices for those that provide apps to the public, better privacy practices, kind of building something better from the beginning? And as Florian mentioned before, this project was headed up by 4 members of this faculty, including Teresa Scassa and Jenna McGill, and also Suzanne Bouclan, who couldn't be here today. I'll just explain a little bit about what motivated us to do the project, and then Teresa's going to talk about our process and also some of the challenges. And indeed, some of the challenges she's going to talk about are going to feed into exactly what Lisa said about this very complex data ecosystem, and we found that to be a major factor in us trying to puzzle through this. A bit of note on scope. We do have the title mobile apps. Our project really was focused on both mobile and web-based apps. We didn't distinguish between them. And our focus is also on legal apps, so a particular type of app. What is a legal app? Certainly more a term of art than science. Really broadly, we were looking at taking a flexible view. In our mind, a legal app was basically mobile, web-based tools that help or purport to help people with legal tasks. And we were very much focused on apps that were public-facing. So there's a variety of apps that can help lawyers, for example, do their billing, manage their cases, those kinds of things. We were looking at apps that were purporting to help people with legal tasks or helping people with legal tasks. So what might be those types of apps that are out there? Some apps can help people fill in forms. So, for example, if you wanted to prepare a will, there's apps now that can help you do that, both by public and private actors. There's an app that's being developed that helps people apply for pardons. So if you have a criminal record and you want to apply for a pardon. Other apps maybe have a bit more unique functionality, I guess, in the sense of if you're detained by the police, for example. There's a number of apps that can help record that encounter, also provide you legal information about your rights. Some apps that help people incorporate businesses. So a variety of different kind of diverse functions. But we're seeing these things come up in the legal field. One app can tell you where you can fly your drone. Any people have drones out here? Might want to check that out. So why do we do this project? Our motivation really started with a previous project. So about 3 years ago, a team of us started hearing about, apps. There's an app for that. People have heard that. We started hearing about some of these apps being developed to help people with their legal problems as a way to help access to justice. But there really wasn't much information out there about what was out there. So we basically did an environmental scan and tried to just really gather like what tools are on the market. If you go into iTunes Store, what kind of apps can you find out there? And so we did an environmental scan, found kind of about a couple dozen things out there that would fall within our classification. Looked at the United States too, maybe unsurprisingly, kind of hundreds there. So there's definitely, we did see that there were things out there. So we did that kind of scan to saying what's out there. We also wanted to start kind of thinking from a policy perspective, what might be some of the risks and opportunities associated with these apps. So what are the benefits? We hear about access to justice, apps helping that. Trying to investigate, is that really true or false? What do we know about that? Thinking about potential downsides, so things like accuracy would be, something you'd be concerned about, quality. And what we found is there really wasn't any empirical research out there on this, though we could identify all these potential risks and benefits. So one big area of risk we identified was privacy, probably unsurprisingly. Privacy we know is a huge issue when it comes to the public using technology, a huge issue coming with apps, using apps. There's a story on the weekend about what Facebook's pulling from your health apps, your heart rate, all kinds of different types of things. And then we also thought about legal apps, maybe some of the particular privacy issues that might be unique or heightened there. So one concern, you have a member of the public pulling up an app, provides them with legal information, is that they may mistakenly think that their information they're plugging into this app is protected by solicitor-client privilege. Okay, and just because a legal app, of course, is giving you legal information, that doesn't mean that information is privileged, but that's something the public's gonna need to know. Relatedly, the information that a member of the public might be putting into a legal app may be highly sensitive. And this is particularly the case if you're using an app to get help with a legal problem, maybe a divorce, or maybe you have a criminal record you want to get a pardon in respect with. And that's going to be important from a privacy perspective for a number of reasons. For example, if you're using an app to get information about a divorce, potentially you don't want then ads about that app coming up on your home computer for your spouse to look at, for example. You can kind of think of domestic violence issues. You can think of a variety of different ways why information you want put in that app you want to keep private. And these issues with lack of privilege, sensitivity also fit into the fact that when you're dealing with a legal context, there's also this heightened potentiality that third parties are going to be interested in getting that data, either compelling it through a legal process or requesting that information. So think about a police encounter app. You have a filmed encounter with the police. Your statements are on there. That could potentially be gathered by law enforcement authorities. Other apps may be collecting financial information. Is that going to be discoverable in a civil litigation process? Think about traveling across the border. Maybe you have an app that tells you about marijuana laws in the country. How's that going to affect you traveling? There's apps that deal with immigration status, will that be of interest to foreign authorities? And also, apps may want to help people understand their legal rights by pulling data from, for example, court cases or other public registries. And there's actually going to be particular privacy obligations that are going to come into play. That information is public, but there's going to be restrictions on how that can be used. Developers need to understand all this in the legal app context. So there was these concerns we identified. So again, apps in general, privacy issues, legal apps, particular privacy issues. And when we looked at that landscape, when it comes to apps that are serving the public, what we really saw was that it's kind of a very, fragmented sector, if you can even call it that. A lot of small players populating that sector. So lots of interesting stuff being developed, for example, in law school classrooms, some incubators like at Ryerson. But often it was individuals or small teams developing these, and not that they didn't have the best of intentions, but they're not people that necessarily have huge kind of compliance departments or huge legal teams to help them, understand their privacy obligations. Also an area where we saw lots of instability. So we were trying to, track what's out there. We saw things disappearing really quickly, new things coming up, sometimes things not being updated. And so for us, that really suggested that there could be use in developing some sort of best practices tool. So let's say you're a person developing an app, you're a person running a law school class developing apps. What do people need to know about their privacy obligations? How could we help people develop better tools, kind of a privacy by design perspective from the get-go? So really wanted to think about creating something simple and usable that people could want to pick up and use and help them develop better privacy practices. I think now Teresa will talk a little bit about how we actually did that. Well, that's the hard stuff for you.
Thank you. So, I'm going to talk a little bit about some of the things that surprised us a little bit as we were working on this project. And so one of these things is really related to our whole approach to this project. Now, we had proposed developing a kind of sectoral code for legal apps. So as Amy's explained, the focus was on legal apps. The Office of the Privacy Commissioner of Canada is interested in sectoral codes and was interested in our application because it related to developing a sectoral code. It's becoming increasingly challenging to deal with privacy across a broad range of contexts. And so the sectoral code, a code of practices for a particular sector, is one way of trying to customize the rules in PIPEDA or explain them in specific contexts, and so can help with privacy compliance by making by tailoring the rules to specific contexts. So that was our idea heading into this project, but we quickly realized that there were some real challenges with the concept of a sector, certainly from the point of view of our project. And as Amy has already mentioned, this was an area where it's relatively new, it's very dynamic, and it's perhaps too new and too dynamic to even think about it as a sector. And so this was one of the challenges. The other challenge, of course, is that when you're talking about technology, I think it becomes even more challenging to think in terms of sector. I think technology is flattening the concept of sector. So we were doing a project on legal apps. A lot of the privacy, not all, but a lot of the privacy issues relating to legal apps are privacy issues that relate to all mobile apps. And so there's some that, for example, Professor Austin's was talking about or was looking at in her AppTrans project, and they're not particular to the legal context. And so, in a sense, it doesn't make sense to be thinking about a sectoral code for legal apps when the bulk of the privacy issues are shared across all apps, and that's not a sector. That's just a lot of stuff going on, touching health, touching all kinds of other areas. One of the comparisons we made in discussing this was with the auto industry. I mean, you could think of the auto industry as a sector, or at least at one point you could think of auto manufacturing as a sector. But if you think about a sectoral code for privacy in the context of connected and autonomous vehicles, the technology immediately just takes that outside of the auto industry entirely. You've got you've got privacy issues relating not just to the cars and their black boxes, but to devices that interact with those vehicles, to the onboard navigation systems, to the onboard entertainment systems, to the telecommunications service providers that those systems are connected to. And it's not really about the auto industry anymore. It's about it's about mobile and interlinked technologies. So the sectoral concept became problematic for us. And of course, there was also this issue of legitimacy of us undertaking this project. I mean, who are we? We're a group of legal academics. We're not app developers. We're not legal app developers. We are in the legal world. And again, the concept of the sectoral code is really about people within a sector sitting down together and finding a collaborative way to work to come to an agreement on best practices for privacy that the membership, the stakeholders within that group are satisfied with and that comply with the law, so that there's general consensus around this code, and that's what makes the code work. And again, we didn't have that kind of sector with legal apps. The development is too diffuse, it's too new, and so it would be hard to come up with something that would be legitimated in the way that sectoral codes are, although we did try to consult and we brought in developers, and I think we still came up with something that's good, but it just changed how we were thinking about the project. So if we turn it into a code of practice or a code of best practices for legal app developers, this is eventually how we began to think about the project that we were engaged in. In terms of the code of best practices, we also ran into some challenges with this. Perhaps they shouldn't be that surprising. A lot of the development of legal apps is taking place in the context of universities or not-for-profits who are interested in using technology to improve access to justice in a variety of different ways. So a lot of these actors are small, poorly resourced. Often they're doing this to try, as I said, to try and improve access to justice, not necessarily with a profit or cost recovery motive in mind. They don't have a lot of resources. And with limited resources, of course, there are real benefits to having a privacy code of practice because it can provide information and support to those developers about privacy issues in an accessible and low cost or no cost way, and can help ensure that privacy issues are addressed at an early stage in development, especially within a group of developers who may not be able to afford independent access to legal advice. But we also heard from developers that if our code was too burdensome, it would discourage the development of apps. So it was one of those things where there's a need for information, there's a need for support, but there's a concern that if we produced a 50-page document with lots of footnotes and references, that these developers would look at it and go, all right, I'm going to do something else. I'll develop a new game or something that is just going to be less complicated and make some money. So this was an interesting balance that we had to negotiate. How do we make it usable and not too scary? We also found that the developers we talked to wanted clear, concise answers to questions, things like checklists, things that, again, made it very simple and very usable. But we found that hard to do. And I think that's partly because we have lawyer brain. And so it's impossible to think of any legal question as simple or straightforward. They're always complex. They always depend. The answer always depends on a whole variety of factors. So it was partly that. But it also is partly due to the fact that there's such a diversity of legal apps with so many different objectives and dealing with so many different sectors, types of information, and so on. And so it's hard to create something simple and straightforward that can be generalized across this very broad range of apps. And we also felt that, lawyer brain aside, there still were some issues that were fairly complex and that were important. And just to give you a few examples, one of them is which data protection law applies. If any. So if it's not a commercial, if it's a non-commercial app, PIPEDA is not going to apply because PIPEDA applies to the collection, use, and disclosure of personal information in the course of commercial activity. So then you have to think about, well, what's commercial activity? And how do you define commercial activity? When do you know whether you are actually engaged in commercial activity? And so it's not uncomplicated. It's also important to think about the fact that because of this crazy patchwork of laws we have, PIPEDA might apply to some legal apps, but it's not going to apply to all legal apps, particularly if they're really meant to deal with legal issues that are within provincial jurisdiction, and therefore the app is going to be operating within the a particular provincial jurisdiction that actually has its own private sector data protection laws, like BC or Alberta or Quebec. And to make things even more complicated, in BC, it doesn't matter if you're a nonprofit, it doesn't matter whether you're engaged in commercial activity or not, the private sector data protection laws will apply to your app. So you can see how the checklist starts to get really complicated. Personally, I think this is a problem with data protection law in Canada. I think it's a dog's breakfast. It's a mess, and I'd like it to be better, but it's not going to be. Anyway, but you know, it's a really complicated area in some respects, and it makes it hard to give simple and straightforward, useful guidance. Other issue, I've mentioned commercial activity, that can be complicated and not necessarily intuitive. What is personal information? That is not necessarily intuitive for many people, right? And personal information is information that can be connected to an identifiable individual. So, you know, your device ID on your cell phone, it can be personal information, even if it's just a number. Your IP address on the internet is personal information if it can be linked back to you. And so there's lots of ways in which determining what is personal information can be complicated. Again, it doesn't necessarily lead itself to a simple checklist. How sensitive is the personal information? Well, that's going to have implications for what level of consent you need to obtain. And so you have to think about sensitivity of personal information. So these are just some examples of where it starts to get complicated. And Amy's already mentioned publicly available personal information for legal app developers that connect to registries or public registries or to databases of case law, like Can Lee, for example. Some of that information contained in those databases is personal information. It's publicly available personal information, but that doesn't mean it can be used for any and all purposes. And again, not something that's simple to explain in a checklist. We did do our best, and we understand the importance of that kind of feedback that we receive from developers, but it does make the task very complicated. The other issue, and this is something that Professor Austin talked about in her paper, was in thinking about a code for developers, the threshold for commercial activity is usually crossed where you have an attempt to monetize the app in some way, which can include, for example, a very common form of monetization is running ads through the app. And where that gets complicated is, of course, this relationship between your app and the ad service, the advertising service, and the fact that the advertising service may be collecting personal information from your app and doing things with it that you aren't fully aware of. And so drafting a privacy policy and thinking about privacy in that context does become complicated. Another issue that we thought about was this whole issue of the relationship between privacy law and the Office of the Privacy Commissioner of Canada and law societies and the role of law societies when it comes to legal apps. Now, law societies have shown some interest in legal apps. Often their concerns relate to whether this is the delivery of legal services. In other words, whether it's an aspect of the practice of law that needs to be regulated by the law societies, and their focus hasn't necessarily been on privacy, although there are ethical issues that are tied up with that. And so some of the questions that we struggled with was how to navigate that interface between the jurisdiction of the Office of the Privacy Commissioner of Canada and law societies when it comes to creating some kind of code of practice for the development of legal apps. Some developers told us that because compliance is so complicated, they'd feel better if there was some form of certification process or trust mark for apps that would say this app is privacy compliant. But of course, that raises the question of who should be responsible for doing that and who should have a say in determining when an app is entitled to that trust mark. Is it something for law societies or is it something for the OPC, or should they be working together on that sort of thing? In terms of the fate of our code of practice, we feel that we've come up with a pretty good document. And something that is potentially useful to app developers. But then in thinking about what to do with it and how to disseminate it, we encountered yet another question and another problem that we haven't still worked out. We have considered posting it online, creating a website for it, and some developers have indicated that it would be most useful if it was done up as a layered HTML document or even an app, where you could look at one layer, and if you wanted to go deeper on any of the particular issues, you could go deeper, but you wouldn't have to. So you can imagine how that might look like, what that might look like. Our concern, of course, is that the technology moves very quickly, and the law may change, and we have ourselves limited resources to keep track of and monitor the extent to which our code of practice is still up to date, both with privacy laws and with any changes in the technology. And we could plaster it with disclaimers, but that, of course, will reduce its value as a source of legal information for users. And so we still haven't worked out what we're going to do about the fact that that we ourselves find ourselves to be in this problem of how do we make this document useful in an environment that's changing so rapidly. None of this is meant to be discouraging. We still believe in our project, and we do believe we've come up with something useful. And we think that some of the lessons that we learned in the course of this project are going to be useful as well in terms of thinking about how to tackle this project moving forward. But it's complicated, I guess, and in some ways, perhaps it was more complicated than we thought at the outset.
Hi, everyone. I'll be really brief. I'll just tell you my story, and then hopefully you have some questions. So I'm Sam. I started a legal technology company like 5.5, 6 years ago. 4 years ago, we launched an application on the internet that allowed people to get divorced online. Basically, from the beginning, the Law Society investigated me. I'm a lawyer, so that was how they sort of got their hooks into me. And they investigated me for unauthorized practice, impermissible business structure, a bunch of other sort of complicated stuff. They didn't like how I advertised. It wasn't just me advertising. And so we spent basically 2 years. We processed about 5,000 people through our application. During that time, we were the largest family legal services provider that I'm aware of in Canada, for sure. We basically handled uncontested divorces in the province of Ontario. And then we shut it down about 2 years ago because the Law Society investigation wasn't ever really going to go away. And I honestly felt like I had better things to do than continue to fight them and spend money. When we shut it down, we had a ton of personal information on people, information that like most people would not be comfortable giving me right now. And so we made the decision to delete it. And it was a pretty easy decision for us, but that's because it was something we believed in pretty strongly. We got offered by realtors more money than we made the entire time we ran the app, just to sell us the email lists, because lead gen is a big problem for realtors. And so we decided to delete it. We didn't want to mess around with any of that stuff. Along the way, though, we discovered how easy it is to target people on Facebook. In particular, we could generate like a reliable separating couple for about 6 cents. So, you can sort of figure out how cheap I can buy your personal information from Facebook. And like the Cambridge Analytica scandal is a great example where I think many members of the public were very surprised by what Cambridge Analytica had access to. From our perspective, we were actually a little upset that they didn't have to pay for personal information. We were paying about 6 cents a user. So that's sort of the difference, is like they got preferential financial treatment and we didn't. And so, I think part of the role I'm here on this panel to play is like I've done this stuff. I've broken some rules. I'm sort of not a law professor, and well, I'm really not a law professor, and I don't. I mean, I've sort of lived in those trenches. So rather than take too much more time, hopefully there's lots of questions. Unless there's anything you guys want me to
Can you
add.
just explain that, go into a bit more detail? You said, so 6 cents would be the cost for.
Yeah.
So how does Facebook piece that together, and how does that work?
Yeah, so it's an auction is the way they work, and basically like you go in and you can adjust how you bid accordingly. So you pick your demographic target. So for example, the 6 cents a user, I remember the profile well. It was women over the ages of 55, located in the GTA, who made more than about 100, or had like a net household income greater than $100,000, and were going through some life changes. So had had a child in the last, I think, 7 years. We had like a pretty robust profile for that. We could generate, I think, 15 users a week with that profile. The interesting part, and why Cambridge Analytica was no surprise to me, is the profile I've just described, the very act of like clicking and signing up, linked their email, we linked their profile to the ad campaign we'd run. So we knew all that information about them implicitly. Like they didn't explicitly ever hand it to us, but we had that profile because we knew the source. And Facebook is very, very reliable at giving you that information. So, or knowing that information about you, I guess. That. Yeah.
I just don't know all the proxies for divorce, so I can try and avoid them in my life.
Yeah.
I've had a couple kids, so I guess.
Don't have kids.
Maybe with that we can open up to some questions. Maybe some questions from the audience.
I actually have one. So I think it's, well, Teresa, you mentioned many of the issues we have with data. And Lisa, you were like thinking that maybe regulators should have a role like to play. Do you think they're like equipped to do this? So first, like with respect to the provisions in the statutes, but also like with the staff.
So I'm happy to start. So I mean, there's nothing that prevents, say, the Federal Privacy Commissioner to initiate an investigation of an area. So that part is okay, but the question is on what basis and how do you know what to investigate, right? And it's not like our regulators are flooded with money either, right? So they have to figure out the best use of their resources and the statutes, I can't remember, I don't have it in front of me, I think it's like reasonable, there has to be a reasonable basis for investigating. So it's not just a random audit, unless you think that there's something about an industry that makes a random audit reasonable, maybe you can make that claim. So how do you figure out where to look, right? And if the data, what concerns me is if the data practices are basically hidden from view for all intents and purposes, right? So this isn't just, I'm going to read your privacy policies and figure out, what concerns me, which already is a staggering undertaking given the thousands and thousands and thousands. Like there's 3.5 million apps in the Google store at the moment, right? Like, so you can't do that. But even if you could, that's not the problem that we discovered. We discovered that there are data practices that aren't being declared in the privacy policy. So how are you supposed to get at that? So regulators have investigatory powers, great, but they have to figure out when to use them, right? So there's a real problem there, I think, actually, in how you actually go about regulating in this area and figuring out what are the pieces of kind of infrastructure that have to be in place so that we can do this. And that's why, as a philosopher, I'm actually became super interested in technological tools that can help in this. Not to automate, I'm not on that bandwagon, but to help sift through this overwhelming amount of information to prioritize and see, it looks like there might be a problem over here, and I have a basis to go and take a closer look with my regular toolkit of ways of looking at this. Because if we don't do that, I don't know how you're going to actually regulate in this area. And if you can't actually effectively regulate, you can have all the law in the world you want. There's no law, right? You're practically immune from it. And I have to say, the privacy policies we saw, like the ones that we manually looked at, were god awful. like these weren't subtle problems; they were just god awful. They shouldn't be out there. So.
Yeah, I mean, I think there are deficiencies in terms of enforcement, so that and some of them are deficiencies in the law, and some of them just are complicated because a lot of the, especially if you get into the mobile app context, you're going to have actors who are offshore, and it's always difficult to think about enforcement when you're dealing with offshore actors. So enforcement's an issue. I do think that the commissioner has been, or the Office of the Privacy Commissioner has been looking at ways to try and improve voluntary compliance. So funding our project was part of that, right? Just to come up with a code of practice that's going to be accessible and useful and that's going to help people in a particular sector comply with the law. And there are other initiatives of that kind, and the Commissioner is also issuing guidelines more frequently in terms of how they are going to interpret and apply the law, and again, with an idea to helping organizations become more compliant with the legislation. So trying to encourage compliance is another possibility, and I think that there are other tools that have always been bandied around and that keep coming up, things like certification systems and trust marks and other things, other ways in which consumers can be assisted in making informed decisions about who they're going to do business with. So there are a lot of, there are some existing tools, there are a lot of potential tools. I think there are gaps and defects in the legislation. I do also think that the legislation hasn't been keeping up with just the dramatic change in the value of data within the economy and how to deal with compliance in that context. So, yeah, I think I just did lawyer brain and made it complicated.
Yeah.
Sam, you touched on, and I guess a few of you touched a little bit on access to justice, and I'm just curious what your opinion is. Is it naive to think a lot of these acts are going to have any impact on access to justice, and it's really just businesses getting a profit? And yeah, I guess if you could just touch on that a little bit more.
Well, I'll start and then I think a couple of things. I think it's really important to be specific when you talk about legal apps. So what type of I think there are certain types of problems that technology can potentially help with. So one big area that we're seeing more and more of is automation of court forms. So hugely complex. We know majority of people can't navigate these. If you did something like a TurboTax for a court form, that can be extremely helpful. Versus kind of something that's unrealistic and not going to happen as a robot lawyer in court, for example. So somebody talk kind of about legal apps and access to justice. I think it's important to be specific. One of the hugest issues, I think, certainly in Canada, is monetization. So a lot of private actors are trying to develop this sort of thing, but it can be very difficult to do that at a scale where you can actually make some money. So it may be public actors. So for example, there's lots of legal information societies in different provinces that are developing tools that I think are really helpful. And I think that's maybe where we're going to see the most useful things be developed. We have very interesting, I don't know if people have heard about Do Not Pay, but an app that's in the United States is getting a lot of buzz, privately developed, trying to help people with a variety of things like funding parking tickets, small claims courts. Right now, it's getting a lot of money in, but Josh Browder, who developed it, hasn't really explained about how he's going to actually make money and sustain that. And is it going to be through selling user data? He said no, but it's also a big open question about how to do that. And because also law is so localized, so for example, if you're developing an app that's going to help people with family law in Ontario, it can be more tricky to spread that out across Canada. Criminal law maybe is one area that's more national, but then you have kind of huge, I think, quality and unauthorized practice concerns with doing that kind of thing. So I think there's other promise out there, but we have to kind of think about it's not going to solve all of our problems, but it can, I think, provide some certain targeted solutions. I think we need to be realistic and think about that, so.
Yeah, I think technology doesn't solve the underlying issues in a lot of areas. So like family law is a really great example. There's mental health issues, like literally everyone getting divorced is going through the worst time in their life. There's no technology that's going to fix that. So I think that's one sort of criticism I would have leveled at my sort of past self. I think that the other sort of criticism is borne by everyone in this room who's going to graduate, which is like we've made the legal system really, really complicated. We let people fight about spousal and child support, like they're formulas, right? We have spousal support advisory guidelines, we look them up. There's no deviation already, so like pretending that there's a fight, pretending that you need to retain a lawyer to settle on some of the like financial consequences is ludicrous. I was last week in Vancouver talking to the family law judges from across Canada about this, and they all agree, like, there's no reason to fight over the financial consequences in a divorce. We know how assets are divided. We've created a range in spousal support, which is probably foolish in hindsight, but whatever. So I think like we're not addressing the fundamental issues. So that's family law. I think when it comes to a lot of the other challenges with access to justice, a lot of the criticisms that I just leveled can be leveled as well. Like in criminal law, there's addiction, there's mental health. Like these are primary drivers of the reasons people are committing crimes. Like very few people wake up in the morning and go like, I want to be a criminal the rest of my life. They're out there, but not a lot of them. And so an app isn't going to address that. Or, a meditation app is better positioned to address that than a family law app or a criminal process app. You mentioned form filling. I think we've made the forms complicated. If you want to navigate the family law process like uncontested, you'll write your name and address like 15 times minimum. I have no idea why you have to do that, but that's how we've designed it. And I think forms just get layered on. We don't remove forms ever. So I think like we haven't addressed like the systemic problem, and we're trying to sort of like patch it with technology that's really poorly suited at the emotional consequence. The last example I'll sort of give you is with our family law app. One of the things the Law Society was concerned about was us talking to people. If there was human to human contact, the Law Society felt we might give them the impression that there was like a solicitor-client relationship. And anyway, I'm not going to get into that. We served about 5,000 people through the life of our app, and what we discovered was maybe like 10% used the like analytical tools we provided them with. Every single one of those 5,000 people sent us an email telling us their story, and it was unsolicited. Like it was not part of we actually took down contact information because they'd call us at night. We get into the office and there'd be 40 voicemails some days from people just like trying to share the situation they're in. What we learned was like people wanted to be heard. They didn't want the forms filled. They didn't want the process managed. They wanted to feel like someone cared about their situation. And like there's no app on the planet that solves that problem. And I think it's true probably in criminal, it's true in employment, it's true like across the board. It's like you go to your lawyer and you complain, you don't go to your lawyer and like expect real results, or at least I don't anymore.
Do you think some of the answer then is, it gets around that unauthorized issue, and some of those issues you're talking about is lawyers embedding this technology into their practices?
Yeah, for sure. Alternative business structures, like if anyone's allowed to vote in the bench or election, vote. That's one easy.
Can you explain what that is?
Yeah, that's corporations being allowed to own law firms at its core, or having like no longer a partnership structure. Partnership structures are punitive for those of you about to graduate. So you should hope that the candidates are allowed. I think that the other reason for that though is it allows them to come in and do things like flat rate billing. Like when I got investigated, I retained Osler, great law firm. no complaints, but we asked them for a flat rate quote, like how much is this going to be before we go in? And they were like, okay, we'll give you an upfront price on the first block of research. So they did that, and then they blew through that by like a factor of 10 by the time we were done. And when we kept pushing back and being like, we want flat rate quotes all the way along, they were like, it's no longer predictable. We don't know when we'll have to respond. Like, if there's lawyers in the room, you've all told your clients this, so you should be nodding along right now. But like, it's a bit unpredictable, but sometimes, you know, you've got to find a way. So like uncontested divorce, lawyers should be charging $500 to file that. Move it through, should never go to court. You know, we don't do that today. We couldn't find a single lawyer in the province of Ontario, and we called a lot of them, that was willing to do something like that for us. So it's really, really hard to do that in the absence of sort of corporate pressure to drive down costs.
I have a question that's a bit of a two-parter. Firstly, as a consumer, knowing all of this, what can you do to protect yourself from the privacy breaches, to deal with it, like knowing that pretty much everyone has a phone and has most of these apps or whatever? And secondly, as the legal community, what could or what should be done in terms of like next steps to make a change for the better in terms of like for transparency or whatever?
Yeah, the consumer side of it is always a tricky one. I mean, I think that it's very easy to end up with data collection practices on your apps, even if you're really careful, and that you should routinely be looking through some of the settings and what's been enabled. I'm still amazed. I mean, I use an Apple phone. I don't use a lot of apps. I'm really cautious about what I let people collect in terms of data, and I'm still surprised when I kind of clean up my phone. I'm like, you know, why is this app collecting this data, right? And they're getting better at the settings, but it can be surprising. So doing that kind of personal audit and sharing information with other people about, you know, do you do this, do you not do this? But I think I always find the focus on consumers is the wrong focus. We have to get off of it. And start understanding and figuring out better ways to get at. I mean, this isn't so much about this project, but also deceptive practices, the ways in which, you know, consent is gained in sort of manipulative ways, through the interfaces of apps and things like that. To expect consumers to manage all of this, either in terms of figuring out what they're going to consent to and what they're going to complain about, I think is ridiculous. It doesn't work. And we know it doesn't work. I'm not saying don't take controls away from consumers, but take the focus of how we enforce privacy laws, how we investigate, and how we deal with that has to be taken off the consumers. And that's a tricky thing because we've set it up very much in that way.
Yeah, I would agree with that. I think there has to be, we've got largely a complaints-driven model of privacy protection right now, and that's simply not an efficient way to deal with some of these big systemic issues, to have individuals bring forward complaints and have those complaints. It's a huge expenditure of resources on things that are often just so very narrow and specifically focused on one instance, and I think we need to really rethink how we do audit, investigation, enforcement around privacy, and who's engaged and involved in it. I mean, we've also got, I think, a fragmenting of responsibility for different things. What we used to think of as only privacy has competition law and consumer protection law and human rights dimensions now, and so I think there's a real fragmenting of these issues across a range of different agencies and levels of government that we need to maybe rethink in order to have a more concerted approach to the issues.
Are you familiar with GDPR? It's a European data protection regulation. It seems to be the first one that's actually scared some of the tech giants. Are there consequences if I get investigated by the privacy commissioner today?
Well, that's the enforcement issue that Teresa
Yeah.
was flagging.
Yeah, but let's
absolutely, yeah.
actually, like, what is the consequence?
And don't get me started, but if you look at the complaints, the privacy, this just boggles my mind as well, that they still don't even name names unless
That's
you're
the
a bank or a
consequence, name and
telco.
shame, and they don't do it.
They don't name
Yeah.
names, so it'll be, the complaint, the report on the complaint will be that a person, individual complained about company X. And that'll be the discussion, so there's not even any direct consequence, it's tragic.
So GDPR per breach, 4% of global revenue is the max fine. So you can imagine that changed Google's behavior pretty quickly. They have a chief privacy officer now. They're very concerned. They have a framework where you can opt out. GDPR changed the way big tech companies do business in Europe. We get none of that benefit right now, but maybe someday.
There's a real tension in Canada, and right, we're in the process that the federal government is considering its national digital strategy. There's always talk about reforming PIPEDA, very rarely any action. So we're always in that kind of cycle where we're thinking about reforming data protection laws in Canada. But one of the big things in Canada is this fear that, privacy is seen as an impediment to doing business and succeeding in business. And so there's always this fear that if you strengthen privacy protections, then you're going to inhibit innovation and you're going to inhibit small business, small and medium-sized enterprises from operating in the Canadian economy. And so that's the trade-off. If we have more privacy, we're going to hurt our economy. And it's always framed in those terms. And I think this is hugely problematic. I went to a consultation on digital strategy where that was, it was one of these invitation-only things, and the overwhelming perspective in the room seemed to be, PIPEDA is great, it's working great, and if you tinker with it, you're going to suppress innovation and you're going to stifle small and medium-sized enterprises. That wasn't my perspective, but that was the overwhelming perspective in the room. And that, I think, is really very discouraging from a privacy point of view.
I mean, we hear that argument in climate change deniers as well, right? Like Doug Ford's a great example of, like, if you have a green energy policy, you ruin Canadian jobs. It's like those are two totally divorced consequences that no economist has connected. And in fact, like, in general, industries spring up to service those exact needs, like GDPR. Google GDPR and tell me how many ads you get served. Like, there are a million companies trying to service the GDPR problems right now. So it's almost a like false equivalence that they're drawing, which frustrates me.
But I would just add to that when I talk to my tech counterparts and some of the projects I'm doing, they say, but it has to be that easier for developers to comply with the law. So not that there's an inherent trade-off between privacy and innovation, but it does have to be easier than currently it is for, say, app developers to be confident that they're fully complying with the law. And I think that's a really fair point, and I think that from my perspective, at least from the project we just did, that you have to take some of that focus off of just, it's up to the app developer to figure out everything when you've got also, third parties and infrastructure that's giving them the tools to create what they're creating. Where are the responsibilities for the people who are, responsible for those pieces of the data ecosystem? We're not focused on them so much. And it's very easy for them to offload the responsibility onto the app developers, and that's not good for small businesses either. So I do think that perspective has to come into the debate, but not in the terms that I agree with Teresa that we're hearing, which is don't tinker with this because you're gonna, mess up with innovation. But it's still something we have to think about.
I think I saw these last two questions quickly. You and then maybe you. Yeah. You have 5 minutes.
Hope you don't mind if I take this opportunity to introduce myself. I'm new to the law school. My name is Laura, and I just started working this month as the assistant dean of the JD program in the Commonwealth section. And more importantly, I took Professor Austin's privacy law course in 2013. It was the most useful course I took in law school. My general question is about when you're
non-academics or non-lawyers, do people care about privacy, and how do we get them to care? Because I take Professor Austin's point that we need to shift the focus away from consumers in terms of who's doing the work. But I think we really do need consumers to care, because I'm just coming off of 2 years working in politics, and I will say nothing gets government to move like a front page article in the Globe and Mail. So the media has to care, consumers have to care, otherwise the regulators are going to be starved, it's not going to be a priority, it's going to move slowly, the ADMs and the DMs are not going to be, calling people to say, what are we doing about X? So my question is, how do we make sure that pressure from the public is on?
I mean, I think people do care. The whole Cambridge Analytica debacle, which played out in the media, I think showed the extent to which people were engaged and concerned and continue to be concerned. The StatsCan thing that happened not so long ago, I think that the privacy issues were a red herring there. I think the real issue was transparency, but nonetheless, I think it generated a huge and surprising outcry, which again sent a message to government that people are concerned about privacy. I do think people care a great deal about privacy. It doesn't manifest itself in sort of day-to-day activities because it's impossible to care at that level. We all have to get on with our lives. I mean, our phones are doing stuff right now that we have no idea, like really very limited knowledge or idea about. It's impossible to keep on top of everything that's going on. Almost everything we do now, every communication with our university as students, you have to go through a digital portal. Everything we do online, everything we do on our phones, all of our purchases and transactions, everything is involving data collection and everything leaves a data trail. And that's too much for people to manage. And so I think it's too easy for companies and for politicians to say, well, you see, people don't care about privacy because they consent to all of this stuff. I mean, it's too much to manage, and we need to have other solutions, as Lisa has been saying, that are not focused on the consumer, because this is too much of a burden to put on individuals. But they do care. And they care in lots of ways that I think are quite visible.
And I think on the developer side, I think, at least in this kind of sector, I think people do feel a bit, they're worried about adding extra layers, so there was concern about that in terms of talking about privacy. But I think what we heard is that there is a genuine desire to engage in good faith practices, but how can we make it something marketable to them? So I think that's really where we heard a lot of push for a quality mark and some kind of way that they could actually use that, because they do have a sense of public care, so how can they signal to the public they have a superior product? And then there's big questions about who can kind of manage that. Any other, maybe we'll get to, we have 1 minute for the last question.
I think you're out of time.
Oh yeah, okay.
Respectfully.
Unfortunately, we couldn't hear your question then, but thanks so much for everybody coming out, and enjoy the rest of your day then.